இப்போ ஓகே நினைக்கிறேன். ஒரு லைவ் போகிறேன்.
We are live at Teams, and a warm morning to all the dignitaries, guests, and participants. We are here for the fourth and final scientific session. This final scientific session belongs to none other than Dr. S. Muthuvenkatesh sir, Associate Patents, Anand and Anand Advocates, Noida, UP, India. He will be conducting his session on title Linking the Dots of Academic Intellectuals to Patent. And now I would like to invite Dr. S. Ramkan sir, member of organizing committee and head of the department, Pharmaceutics, Karpagam College of Pharmacy, to give an introduction on our speaker. Over to you, sir.
Yes. It's indeed honor. Before going, let me confirm, is it audible? Yeah. It is indeed honor to introduce the speaker, Dr. Muthu Venkatesh Sudalai. Sir has been having a wide experience in various practice area and industrial focusing such as pharmaceuticals, agrochemicals, industrial chemicals, metallurgy and materials, polymer, natural products, nutraceuticals, drug delivery system, food processing, medical devices, biotechnology and life sciences. Few of the career highlights of Muthu Venkatesh is Muthu Venkatesh S is a patent associate at Anand and Anand and involved in the firm patent practice. He has a doctorate degree in medicinal chemistry and pursuing law. Muthu Venkatesh is a registered patent and has been practicing with the patent office. In the span of about 5 years, he has experienced his client in a pre-grant and post-grant patent opposition matters. His practice area also includes providing opinions and strategies on patent laws in India, drafting of patent specialization, patent searches, validity, patentability, and infringement options. Before becoming a patent professional, he has been involved in teaching and research in the field of medicinal chemistry. He has authored research papers in journals of international repute. He is also an inventor in National Patent Application number 1290 Delhi 2014, which is still pending with the patent office. And prior to doctoral degree, he was involved in teaching of pharmaceutical sciences in the pharmacy colleges. So I'm sorry, I may say about the educational background also. Dr. Muthu Shulai has been started his career in by doing his graduation on pharmacy in KM College of Pharmacy, Madurai, Tamil Nadu. He did his post graduation in VIT in the Department of Pharmaceutical Chemistry and followed by post graduation diploma in patent laws from Telangana. He awarded doctor in pharmacy in medicinal chemistry from BITS Pilani. Sir is also a GATE qualified in pharmaceutical sciences in the year of 2004 and 2005. He is a recipient of DBT, JRF, and UGC fellow doctoral researchers. He has been affiliated with various governing members bodies such as a registered patent agent, SNCI, APTI, and IPA. With this brief introduction, I feel pleasure to welcome our today's speaker, Dr. S. Muthu Venkatesh, Associate Patent, Anand and Anand Advocate, Noida, to start his session. Over to you, sir. Thank you.
Thank you very much. And I like to thank Karpagam College of Pharmacy and the principal, Dr. S. Mohan, and the organizing committee, and especially my colleague, Dr. S. Ramkan, for giving me an opportunity to have some highlight on patents, which I have been practicing for past 5 years as of now. And so let's move on to the presentation. So the topic of the presentation today that I will be discussing is linking the dots of the academic intellectuals to parents. So we'll be dealing about more of like what are patents and how is it useful for the academics. Now, let me navigate through the presentations. First, I will discuss about property. Now, what constitutes an property and why intellectual comes under the property. And I will differentiate between the tangible and intangible properties, that is the intellectual properties, the IP laws in India and its offices, where are they, and then we'll move on to patents, why we need patents, what are patents, why we need patents, and for having a patent, what are the criteria that are necessary for having a patent, like novelty, non-obviousness, and industry applicability. We'll discuss in details. And then what does not constitutes an invention, what cannot be patented, and then what is the patenting process that is required to get a patent, the key points that need to be memorized, and the final words, that is the words of caution. So let's move on to the presentation. So this is the kind of property, like what is a property. Now in the property there are two type of properties, that the tangible and the intangible properties. Tangible properties are those which you can feel by touching, and like you can feel, they are movable and immovable properties. Now movable properties, like you can have a pen, car, furnitures, and all those stuffs. Immovable properties are the land, buildings, and all, and that comes under Transfer of Property Act as per law. While the intangible properties are which are creation from your mind, that is, you cannot feel it, but it's a kind of property. Now that property comes under patent in India. Not only in India, it comes under patent law, that is law of patents 1970. And intellect, that is the intellectual property that is being created by minds, like literary works, inventions, and all those stuffs. Now let us differentiate between the tangible and the intangible properties. The intangible properties are the intellectual properties, while the tangible properties are the that you can feel it, like, right? So I have made a differentiate so that you can understand like what is a tangible property and then what is an intangible property. Like tangible properties, intellectual property rights, also gives the owner the right to exclude others from the use of their property, that is the exclusive rights. Now what is an exclusive rights? They are also called as negative rights. We'll discuss it in our preceding slides, like what is an exclusive right. You get an exclusivity, that is you avoid others from doing certain practices, that is exclusive rights, but we will discuss more in details in the preceding slides. Like the intellectual, now the differentiation between the intellectual properties and the tangible properties. You have the origins. Now where is the origin of the intellectual properties? It is a creation of mind, that is the intellect. That, and the tangible property is the ownership of an existing entity. You get the ownership, you can, that is both intellectual properties as the tangible property, you can use it for your purpose. But tangible property you can, that is it is in perpetuity, the duration of ownership is in perpetuity, that is you can indefinitely you can use your tangible property, that is your land or any of those properties that you have, whether it is an immovable or movable, you can use it indefinitely. But for intellectual property, it's a fixed period of time. The leverage is given only for a fixed period of time. Now the jurisdiction is only territorial or jurisdictional right. Right, if you get a patent in India, or if you get an intellectual property right in India, you can use it only in India, not in any other countries. Like if you want to have your own rights of intellectual properties in any other country, like in Europe or in US, you have to apply and get the rights from the patent office, concerned patent office, that is the European patent office or the US patent office. But tangible property is restricted to that specific property which you have it, right? So now next is the mode of operation. Intellectual property similar to that of tangible property can be licensed, leased, donated, that you can keep it for a mortgage, and you can have money and all those stuff similar to that of the tangible property. Now the examples of intellectual properties or the intangible properties are patents, trademarks, copyrights, and all the similar that comes under the intellectual properties, while the tangibles are land, vehicles, and objects. Limitations and expectations, yes, you need to fulfill certain limitations and expectations to get a intellectual property. Now that we'll be discussing in our preceding slides. Now this is an illustration that demonstrates clearly the what is an intellectual property rights. You need to invest something or the other to in order to achieve some property, right? So here in intellectual property or the intangible property, you invest your intellectuals, that is your mind, you apply your mind, you apply your knowledge, that what you have gained throughout your academic career, that you invested, that is the Lord of Wisdom, Saraswati, you invest your wisdom. in order to gain intellectual property. With that intellectual property, you create monetary benefits, right? You create monetary benefits, that is the Lord of Wealth, that is Mahalakshmi. You create it, the monetary benefits out of it. Now, next is the definition of intellectual property. What constitutes an intellectual property? What is the definition? What it means, intellectual property? Intellectual property includes the right. It's a right that is being given relating to literary, artistic, and scientific work, performance of performing artist, phonograms and broadcast. They have every artist have their own specificity, right? They are unique. Everybody is a unique, even though everybody have the knowledge of singing, but everybody is a unique. So similarly, the performance of performing artists, phonograms and broadcast, that inventions in all fields of human endeavor, wherever the human intervention to create an invention falls, it falls under the definition of intellectual property. Scientific discoveries, industrial designs, trademarks, service marks, and commercial names and designations, protection against unfair competitions, and all those rights resulting from the intellectual activity, that is something, wisdom, investing the wisdom in industrial, scientific, literary, or artistic field. This is the definition of intellectual property. Now, the broadly, intellectual property rights are classified into copyrights and the industrial properties. Now, the copyrights, it's a separate category that consists of musical, artistic, and dramatic work. Now, why this is being a broadly classified, we'll understand in our preceding slides. Now, the industrial property constitutes of patents, industrial designs, trademarks, geographical indications, trade secrets, protection of new plant varieties, layout, designs, topographics, and integrated circuits. Now, the basic principles of intellectual property. What is intellectual property? What is the basic principle of it? It is a contract between the creator or the inventor and the sovereign state or the specific country. That is, an inventor comes out with an invention. Now, to disclose that invention, in order to disclose that invention, to the specific country or to the specific nation or to the public domain of that specific country, so he discloses it. For disclosing it, he gets an exclusive right, that is revelation, protection for revelation. He comes out and reveals the invention, and for revealing it to the public domain, he gets an exclusive right for a certain period. Now, it is a time bound. It's a balance between the right of a creator and public interest. So there should be a balance, always need to be maintained. If you are giving a monopoly, there should be a balance need to be created. If they are disclosing, if he is disclosing something, his invention to the public, that both the inventor as well as the people of that nation has to be balanced. That interest has to be balanced. So that is a right of limitation and expectations. Now, what are the limitations and expectations? That expectations are, he need to reveal it completely without any confirm that is consignment of the informations regarding the inventions. Now, as we are like in a 2020, the my business has been grown up to a very great extent. Now it's a transboundary, like business has been like everywhere. So there are international treaties which govern this intellectual properties, like Paris Conventions for Protection of Industrial Property 1883, Berne Convention for Protection of Literary and Artistic Works 1886, International Union for New Varieties of Plants, Biodiversity Agreement on Trade Related Aspects of Intellectual Property Rights, that is TRIPS Agreement, then the Internet Treaties in 1996. So these are all governed by the international bodies, so that actually this is a complete intellectual property is more of a business documents. Now, I will make you simple understand what is the difference between all those stuffs, like the copyrights, trademarks, and all those things, with a simple example of a Colgate toothpaste. Now, the form of writing Colgate, that is the font size and the dental cream and all those things, the way that has been written is a copyright. The font size and the font in which it is being written, it's a copyright. Now, the whole the red color box with a yellow color wavy line and differentiations, that is a whole is a trade dress. The way that has been in the background, all those stuffs comes under trade dress. Now this is a trademark. Trademark is Colgate. The name is a trademark. Colgate is a trademark. Similarly, the toothpaste, that is that the way it holds the container, that is a design, the form in which it is been present, and the content inside, that is the toothpaste, maybe a patented form, or like the content is a patented form, the form of creations. Now the next is just simple example is of a Bacardi bottle. Bacardi, the trade name, the trademark is the sign which is of a bat, and the Bacardi name, the way it is been written, is a trademark. Now the copyright is of the label in which it is being made, the font size and all those stuffs. While the bottle, the cap in which it is being sealed is a patented. The design, the bottle design, the way it is being created, that is the bottle design. And then the trade secret is how they make that rum, the specific rum, the way they make it, the duration or the contents, the what the composition it is composed of. All this comes under trade secret. So now, what is the importance of IP? Why it is so important? Why we have been discussing of so much of IP? The scope of intellectual property is rapidly expanding. Now it's a transboundary. The business have been expanding very fast. With very passing days, people are making attempt to protect their creative ideas. It's very difficult nowadays. It's a age of high communication. The communications spread so fast that your creative ideas, even like just if you drop in somewhere, it gets so fast that it gets to the public, that even before your blink of eyes, it has been transferred so fast. So it need to be protected by the intellectual property right. So this is a negative right, exclusive right. Now why it is called as a negative right or exclusive right, still we will in the preceding slides we will discuss it more of it. Commercial exploitations. These business documents are useful for commercial exploitations, that is to create, generate revenue. It's a monopoly for certain durations. The rights that is been obtained from the intellectual property, it gives you a monopoly for certain durations. That is, you can only sell the product in the market. Incentives for innovation. That is the wisdom that you had input, you get an incentive for it. The protection of consumers interest, that is the consumers what they get is they get the protection for that. Next is the scope covered by IP, intellectual properties. How it's a country specific, as I had already told, it's a country specific, territorial rights or jurisdiction rights, right? If you get a patent in India, it is applicable or valid only in India and not any other parts of the country. So in order to protect your patent throughout the world, you need to enter into the like patent cooperation, that is PCT applications, and you may enter into the country of your choice and you can get your rights in that specific country. Some confederations do exist, like ARIPO, that is African Regional Intellectual Property Office, that consists of 19 English speaking African countries. OIP, that is 17 French. Some are unified, like European Patent Office is a unified, it consists of all the European smaller nations. It is a European Patent Office, EPO we call it as. Then we have this all this intellectual properties, as I told, it is a time bound. Patents is of 20 years from application. Now what is an application? Like there are types of like a priority date, provisional application, and complete specifications. That and all we will discuss in the preceding slides. But patent is totally of 20 years. Design is for 10 years. Trademarks is for 10 years. Geographical indicators is for 10 years. Semiconductor chips layout is for 10 years from applications, and for copyrights is for 25 to 60 years. It depends upon from the applications. It depends upon like which type of copyrights what you are trying to claim it. Now intellectual properties laws in India, it is like that's why we have broadly classified the copyright separately and the other things like separately, like patent designs and trademarks, and geographical indications of goods. This fall under Industrial Policy and Promotions, DIPP. We call it as DIPP, Department of Industrial Policy and Promotions, while copyrights fall under Higher Education's, the Department of Higher Educations, while the semiconductor integrated circuit layout designs, they fall under IT, that is Information Department, Technology, and the protection of plant varieties under Agriculture and Cooperation Department. So now the organization structure of IP office, intellectual property office, that is, it falls under, as I told already, it falls under the Ministry of Industries and Commerce. Office that governs the office of the controller, patents, designs and trademarks, that is in Mumbai. The head office is in Mumbai. The design wing is in Kolkata. The patent office, generally we practice in Kolkata, Delhi, Mumbai and Chennai. We have patent office. Trademarks registries that we have in Kolkata, Delhi, Mumbai, Ahmedabad and Chennai. Geographical indications registries in Chennai, and the patent information services in Nagpur. So this all falls under DIPP, that is governed by the Controller General of Patent, Design and Trademarks in Mumbai. Now, we have gone through patents, designs, trademarks, and all those things, but we are now more focusing on patents, because patent is more that is of useful in, especially for the pharma industry. So we are more concentrating on patents, as our topic of discussion is also connecting dots to patents. So we'll be more discussing about patents. Now, patents, the word is from Latin, that is pater, which means to lay open, that is to disclose or to reveal the invention to the public, to make available for public inspection. It's a techno-legal document. It's purely a techno-legal document. That is a business document. Now, techno-legal, it involves a technology, it involves legal aspect to it. So it both has to go hand in hand to obtain a patent. You require both technical knowledge as well as the legal knowledge to obtain a patent. Now, legal grants by the government. Why the government gives a legal grant, or why the government gives you a monopoly to reveal your invention? That is, it gives a legal grant to encourage innovation, technical development, and economic prosperity. When you're investing something for your invention, you need to get returns out of it. Even R&D, when they try to do all those from the basic scratch research and to come out with a moiety, then do the clinical trials, for doing all those stuff, they have invested so much of huge amount of money. So in order to get the returns, they get the legal grant. Now it is a contract, it's a purely a contract between the inventor and the government for making his disclosure to the public. For that contract, they are given the monopoly rights for a specified period of time, which is very important in the intellectual properties, for which it passes to the public domain. After the expiry of the patent, anybody can sell the products, make and sell the products. Now it's an active right. It's an active right. It's an active right. It's an active right to include others. It's an active right to include others from practicing the invention, and to prevent others from encroaching on his monopoly for a limited period of time. Now, this is the granting monopolies. This is the negative rights or the exclusive rights, what we were talking about. What is that? It is, if anybody can manufacture it, but only the person who has the monopoly of patents, he can only sell the products for a limited period of time. I will give you the more, I will discuss more on this slide. Now, a patent is an exclusive right. As we have discussed already, it's an exclusive right granted for a limited period of time for the disclosure of invention, which has to have satisfy the certain conditions, like it should be new, inventive, and useful or industrial applicability. It is a negative right. Now, why we call it as a negative right? A patent does not give right to make, use, sell, or import a given invention, but it allows the patent to prevent others from doing so. So that is why it is called as a negative right. So that is why it is called as a negative right. Now, or exclusive right. Exclusive right is exclusivity. Only you can do it. It prevents others from doing so. That is, you cannot. It will allow the other also, like the Apple iPhone they have the in US, their Apple only has a R&D. They only do it R&D, research and development, and they get a patent and they give it to the on the license basis to others to make it, but they sell it as an iPhone or from the Apple products as an iPhone. So they have the selling rights, but others also can make it on their behalf, but you need to get a license for it, and in return, or you can also make that particular invention in your own country, but you need to pay a royalty in return to the Apple company. So that is how this business documents work on. And I have given some facts which like India is present facts. India in the World Bank ease of doing business has been rated to 100, has been rose from 100 to 63 as of now. And among top 10 countries for foreign investments, India has been ranked among top 10 countries, and patent filings in India have been increased to 50,667 from 2017, which was around 47,854. Now, why we need patent? The patent, even the research, they invest their money, and in order, if they get a patent, this patent will be developed, which will eventually enter into the market to gain the profit, and this profit can be reinvested into the research. That's how even both, like the R&D as well as the public, gets benefit out of the innovations. So they go hand in hand, both the innovations as well as the research go hand in hand, and this is how the innovations comes more into the public, which will be useful for the public. Similarly, the industries also, they create the innovations which that is, they provide new services to the society, which eventually creating by new products, and that's how the industries also gain their monetary benefits out of this patents. I had just elaborated what I had told in the previous slides. Now, it provides the incentives to the individuals by providing recognition, material award. It provides recognition, material award, encourages innovation by providing the monetary benefits, assures enhancement of quality of human lives, transfer of technologies. Research is only possible if the result of the research are rewarded and protected, and moreover, it also has to reach to the public. When it reaches to the public, it has to be rewarded and protected also simultaneously. So the companies will invest in research only when they are able to allowed to enjoy the fruit of their success from their outcome of the research. Leads to the industrial development of a country, thereby it will promote the industrial development of a country. That's why it, even for in India, it falls under the Department of Industry and Research Promotions. Now, what is patent for inventions? How patents are related to inventions? A patent is granted for an invention which is a new product or a new process. Both product as well as process per patent we have, which needs to have an inventive step and capable of industrial application. Invention includes both new and useful machines, apparatus, device, systems, new process, software having technical effects, any improvements thereon. Moreover, also the industrial application under Section 21 AC, that is of the Indian Patent Act 1970. Now, what are the criteria of getting a patent? What are essential features of getting a patent? You need to have a novelty. You need to have, as already defined in the definition also, it requires novelty, non-obviousness, and industrial applicability. Now, the novelty is it should be new. It should not be published or not used anywhere, any parts of the world. Non-obviousness, it should not be obvious. It should have some inventive ingenuity, that is the inventive features that need to be added to the existing knowledge that already is in the public domain, not obvious to the person skilled in the art. It should not be easy, just mere combine. We'll discuss more on it. Just mere combining it will not be allowed as an invention. Industrial applicability, it should have some industrial applications, that is it should be beneficial for the public. It should not be harmful to the public, or it should not create a nuisance to the public. It should have an industrial applicability, that is it should be useful for the public. Simplicity is not a bar to an invention. Just simple inventions doesn't mean that you will not get an invention. Even simple inventions which will be of a public use will be patented. Now, patents are granted for applications of a principle, application of a principle, and not for the principle itself. Like if you come up with something of like gravitational or centrifugal force or something like which is already existing in the nature, it will not be permitted. But if you are using those principles of which has been already known, scientific principles, and if you are applying it and if you are creating something, surely that will be patented. The first criteria is the novelty. Now, novelty is the first and foremost and important criteria for getting a patent. For getting a patent. Now, the dictionary meaning of novelty is something new and unusual or newness, something which is not known to the public, which is not in the public domain, which is not is in the common knowledge, has to be has like something new. It should be something new. According to Act Section 21L, an invention is considered new novel if it is not been covered, if it does not fall under the ambit of, or if it is not been covered anywhere, then it is known. If it satisfies all these criteria, it is novel. Like if it should not be published in any document anywhere in the world, it should be used in the country, or it should not be used in any country, prior claim in any applications for patent in India, or should not be of a traditional knowledge or oral or otherwise, or a tribal knowledge, or a local indigenous community in India should not be knowing it elsewhere before the priority date. That is the subject matter that has fallen in the not in the public domain. It should not be in the public domain. Simply, it should not be in the public domain. It should not be known traditionally, or it should not be known to a specific community or indigenous, or it should not be published anywhere in the any parts of the world. Now, if you just see this criteria, you may feel that nothing is patentable, but it is not that so the case. We'll understand it more better in the preceding slides. Now, what is anticipations? Anticipation is lack of novelty, is referred to as anticipations. As I had already discussed, something which is known before the priority date, that is the date on which you had come upon or stumbled upon that invention, or and you are going for a patent on a particular date. The date of filing of an application for patent is a priority date. So when you come up with an application for patent on of an invention and you file it on that date, it should not be known before that date, and it should not be prior published anywhere in any part of the world and prior public knowledge or use. Here in novelty, the most important difference is mosaic of documents is not permissible. Now, mosaic of documents, why we say that the reliance on mass of extracts or publication as evidence for prior publications, that is mosaic of our documents. When you challenge any invention for a like novelty, the invention should have to be explained in a single document. Okay, so that means that if you say that okay, this invention is already known in the public domain, you should come up with a publication which is already present in a single document. Like if there is an element ABC in an invention, and you say that AB is present in an invention in a document, and C is present in another document, this is not applicable for novelty. ABC, all the three inventive features or the novelty features of that invention has to be present in a single document. If you come up with that, then it is an anticipation. It loses its the invention loses its novelty. Now, there are certain exceptions to the rule of novelty, that is the use for experiments and trials. That is, if you are you have been you have invented a product and you wanted to experiment it for, on trials, like whether it really is been useful for the public. And if you're conducting some experiments and trials, like the drugs clinical trials, what generally pharma industries does, so that is an exception that falls under the exceptions. Like it comes under polar provisions for experiments and trials for pharmaceutical drugs. Communications to or used by the government or its representatives, like some of the like academic projects are being funded by the government, like DBT, DST funded projects. So when you are revealing it, that doesn't falls under the criteria of novelty. That doesn't fall under novelty rule. That is non-novelty break. Subject matter published use without the consent of the inventor, but you need to prove the diligence here. In this case it is not that so easy, but you need to prove the diligence that it was published or used without my consent as an inventor. Next is the public display or publication of any description in an industrial or exhibitions for reasonable trials. Okay, only for trials, reasonable trials. Here it is very important, it should not be disclosed. Invention, but if it is disclosed and like later on you come to know that it is of economic significance and then you go for a patent, then your own public display or the publications becomes the novelty breaking. Next is the invention published in consequence of the display in an exhibition notified by the government or reading the paper before the learned society or the grace, like presentations in the conference, but it should not exceed more than 6 months. Before that, you need to apply for file the patent for patent, your invention for patent. Next is non-obviousness step, inventive step. It is an extension of your novelty. It is an extensive step. Here in non-obviousness or the inventive step, non-obviousness is an US term, inventive step is an European term, but both more or less addresses the same issue, that it should have the inventive step means the invention that involves technical advances, which is already known. There should be some technical advances out of the existing knowledge and have economic significance or both to make an invention non-obvious for a person skilled in the art. That is, some inventive ingenuity has to be included, and you should come out and say that yes, the drug it has a better bioavailability or it has a better drug release than the existing knowledge. Like by using certain polymers, we come up with an invention with better drug release, or instead of 3 time a dose, just once dose is enough. So that kind of inventive ingenuity has to be there to qualify inventive step. The necessity of existence of inventiveness is an in a patent is recognized as the very foundation of patent law. So both, first, if a patent loses inventive step, but it can still passes a test for novelty. But if a patent loses novelty, it will not never qualify a test for inventive step. Okay, so am I clear? So this is how it goes. Here in inventive step, mosaic of publication is allowed when dealing with obviousness. That is, when you have three elements A, B, C in a combination, you say that A and B is present in this document, while C you have been obtained from this document. But when you combine these documents, you should then create something better. It should not be just the mere combination. Mere combination again fails the test for inventive step. It should not be a mere combination from two documents, then it will fail the test for inventive step. But it should create something better that for passing the inventive step. When an invention is said to consist of a novel combination, it's a new functional integration of integers. That is, it should create a new functions. So when you put together these documents, different documents together, it should not be easy for an imaginative man just to combine and obtain the product. It should not. It should be beyond something better from the common general knowledge. So that just by mere combining, if you reach to that particular invention, that is a by hindsight analysis. We call it as a hindsight to reach to the final products. And if the documents teaches something different, when you are combining two documents, the teaching of when you combine the teaching of both the documents, when it is been teaching away or teaching differently what from what you have created your invention, then it passes the test for inventive step. Now the issues involved in assessing the inventive step. it is little bit trickier than analyzing the novelty, because novelty is in a single document, but assessment of inventive step is a little bit trickier, because you need to understand like what are the problems which the invention address, how long the problem existed, how significant was the problem, and like these questions has to be addressed, this all these questions has to be addressed for a patent invention, like how it is commercially viable, why it is commercially viable, how much, how uh, the inventive ingenuity is been present in the present invention, and how it differs from the knowledge that is been already present in the public domain. There are certain tests that has been applied, like teaching, suggestion, motivation, TSM tests, and like several tests, maze test, and so it should be analyzed very trickyly. So here you require some of the expertises to qualify the test for an inventive step. Now, I will give you a better example so as to understand all these questions. I had given some few examples so to make it simpler, like what is obvious and what is not obvious. Slight physical change, dramatic results, it's non-obvious. That is, if you instead of having the normal polymer, if you use some other polymers of the same class but other polymers, and it gives you dramatic results, like in form of a shape, slope, size, or materials, any of those, or drug release. When you use a certain polymers, it results in a better drug release, even if it is a small change, minor change, but still it is a non-obvious. That includes an inventive step, and you can go for a patent. It passes the inventive step. While the non-obvious, new use of an invention, new use invention, which produces an unexpected results, like it does not involve any physical change. You're just giving the same tablet for a paracetamol. If you are giving, instead of an headache, you are giving for something, some other disease which is already not known, and if you come up with that, like the same paracetamol, if you have been injecting into that patient and you are curing that disease, it's non-obvious, and you can go for a patent. Different element but similar functions, like if you have a mobile and if you have a torch and you are just combining it, and you are coming like, okay, mobile has a torch, but still even the mobile works in a different, like if both are been different, they work, they have a similar functions, you are not making anything different. So that comes under obvious, and that cannot be patentable. That is mere assimilation of two or already known products is obvious. Old concept but new form, it's already known. Like if you have a car steering, and like it's already a soft steering, but if you are putting some rubber grip over it so that the sweatings doesn't like affect you while driving and all those things, so but that cannot be patented because that is an obvious concept. While our duplication of parts, just instead of the known parts, if you have been substituting with some other parts, or in pharma industry, if you are just substituting it with like instead of sucrose or glucose, if you are substituting it with some other form of carbohydrates, and you say that yes, we have created something, but it should, if it creates an unexpected results, then it will be a non-obvious. But if it creates the same results, not that much with a difference, but even if you try to say that yes, it has a better solubility and all those stuff, it will be falling under the obviousness criteria. It cannot be patented. Next is the obviousness for like portability, size. You have a hard disk, you just can connect both to the desktop and to the laptop and all those a simpler form of modifications. That is obvious, and that cannot be patentable unless you show an unexpected results out of it. It falls under the criteria of obviousness. Workshop improvements, improvement is the very smaller improvements, minor changes, and it is not patentable. Minor changes, like just outer something like outer designs, or outer, or the form of a drug, like instead of a tablet you are compressing into a capsule form, and then you say that yes, now I had made a different dosage forms out of it. So that cannot be patented. Or well known apparatus, you are just modifying an apparatus, or some well-known characters of an invention, it is not patentable unless and until it produces an unexpected results out of it. Combination invention, yes, it falls under non-obviousness. It will pass the test for inventive step, but you need to prove the synergism. That is, when in a combination, you need to prove the synergism. Instead, when it is being used individually, the effect that is being produced in synergism is better than when it has been administered individually. So you need to prove a synergism. You need to prove that the combination is unsuggested. It is not been suggestible. It is not advisable, but still we are making this combination and it is unexpectedly producing these results far more better than when it has been administered individually. You need to prove it impossible to combine. Both have a very different physical properties and you are combining it and you are creating something new. Yes, it's patentable. Different combinations, prior art references would not operate in combination. Like uh, all these elements is already known in the prior art, but it is incompatible. It will not operate in these combinations, but we are providing it, we have made it. Or the references from different field, out of like something from mechanical or an electronic field, um, like you take an idea and then you apply it in the pharma field, then obviously it is passes the test for ingenuity and it can be, it falls under the patentability criteria. Simplicity of invention is patentable. Even the simplest of the, as already I had mentioned, even a simpler of the simpler inventions, which is perfectly simple, perfectly common. It is not something like you had like very great differences been there, but still it passes the test if it qualifies the necessity, like ingenuity is there and novelty is there, ingenuity is there, as well as it passes the industrial applicability, it is very useful, then it will be passing the test for the patent, it will pass the test for patentability. Secondary considerations, along with your patentability criteria, there are secondary considerations also which will be taken when you analyze the inventive step. That is a commercial success, how much it is useful for the public, how much it is in need for the public. Long felt, it has been long felt but it's been unsolved problem for a very long time, then it will be patentable. Failed efforts of others, there have been so much of research that has been going on but nobody is able to reach to that effect that what you have suggested, then it will also be considered for in inventive step. Copying by others, even by copying by others, you have copied something but still you have produced that results, then it will be surely will be considered as an obviousness, non-obvious, unexpected results, disbelief of the expert doesn't come to the conclusion that yes, this will be possible, praise for the invention. There is a separate criteria if an invention claims a variation from the prior art but which has no advantage to or disadvantages, it will not meet the criteria for inventive step. If something is harmful for the public or if it does not produce any advantages, then it will be obvious, it will not pass the test for inventive step. Now the similarity between the novelty and the obviousness, both novelty and similarity more or less looks the same, but obviousness is a step more to analyze the inventive ingenuity rather than the novelty. So it is a step more than the novelty. You need to pass, but you need to pass both the novelty as well as obviousness for the patentability criteria. Prevent from doing something which is merely an obvious extension. As I told you, that if it is a mere obvious extension, like just by assimilation of the knowledge that is known in the prior art or been used in the prior art before the priority, then it will not be, then it will not pass the test for patentability. Area of inquiry in obviousness, that is how the questions what we have discussed, okay, so is wider than that of the anticipations. So the questions that what we have discussed, what passes the test for novel obviousness is a long, that's why a long jump, it's a one step ahead of the novelty. Even though you pass the test for novelty, one step you need to ahead pass the ingenuity, that is the anticipation. So it is a wider step more than the novelty. Both lack of novelty and obviousness have to be judged on the basis of prior publications and prior use. Now, this judging of the novelty and obviousness, it has to qualify all the criteria, like it should not be in a single document. If it is a mosaicing of document, but it should not just mere assimilation of this mosaicing of documents. It should not be a mere assimilation. It should be more than that. Now, the difference between lack of novelty and obviousness. In general, it may be obvious, new may be obvious. Something new, if it is something new, but it may be obvious. When you assimilate some of the documents, when you mosaic some of the documents, you would be able to reach it. Then it will not pass the test for obviousness, but it will pass the test for novelty. Similarly, what is not obvious, by just by mirroring mosaicing of document, may not be obvious, but may not be new. It may be not novel. It may be a just assimilation of or the known which is already known in the public domain, just by mere like a mobile and a torch. Assimilation of that maybe not be new, but it is not obvious. Further, there are degree of novelty and degree of obviousness which need to be analyzed. How much is the degree of novelty, how much is the degree of obviousness? So depending upon all these questions that is been answered, whether the invention passes the test for patentability will be determined. On the question of novelty and obviousness in relation to any subject, two persons seldom agree. So obviousness is a question of is a question of debate, but how you put it up. So how you argue, or how you uh, what are the essential features that what you put up is very important. Obviousness would not cover practically every case of novelty. Novelty is determined before inventive step. Novelty has to be determined before inventive step. If it loses novelty, there is no then it's not necessary to determine the inventive step, because novelty is lost. Novelty is the primary step. If you lose the primary step, then the whole invention or the criteria of patentability is lost. It doesn't contain any novel element of the invention. Now, the industrial applicability. Among the three, novelty, patentability, and finally is the industrial applicability. An invention is capable of industrial application if it satisfies three steps, three conditions: that it should be made, it should be used, made, used, and reproduced in the same characteristic as that of the your invention. So, if it passes made, used, and reproduced in the same way, then it passes the industrial applicability and it qualifies for an invention or for a patent. Now, what are all that does not constitute an invention? That is under section 3 and 4 of the Patent Act 1970, Amendment to 2005. Section 3 states the non-patentable subject matters, and section 4 are the inventions relating to atomic energies are not patentable, because it falls under Department of Atomic Energy, which take care of the inventions relating to atomic energy, which is not patentable. You won't get any monopoly or any rights for inventions related to atomic energy. Well, section 3 discusses like in section 3 you have subsections A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P. In section 3A, it discusses about frivolous or contrary to natural law, something like gravity. If you're redefining the gravitational law or gravitational, that won't be qualifying for a patent. Contrary to law or morality or public health, something like if you're creating an invention for burglary or stealing some from somebody's house or something of that sort, will not pass the test for invention. It won't be granted as a patent. Discovery of a scientific principle or abstract theory, it also will not be granted. Using scientific principles, if you are creating something novel or something an invention, then that will qualify as a patent, but not as a scientific, just a scientific principle or an abstract theory. New form of a, or new use of a known substance. Mere admixture, just combining of two document or two components, will not qualify. Mere arrangements or rearrangements in like an electronics or electrical device, then G is omitted. The H is related to agriculture, like the method of or killing an insects or those stuffs. diagnostic or therapeutic methods, like blood test and all those kinds. Plants or animals as a whole, it's related to biotechnology. Mathematical or a business model or computer programming per se, it's related to computers. Literary dramatic, that comes under copyrights. Schemes or methods of playing games or presentation of information, that is business methods. Then presentation of informations. Topography of integrated circuits comes under integrated circuits. And traditional knowledges are also non-patentable subjects, as already discussed in our 4 slides. Then the process of getting a patent, you need to apply manually. It's a manual filing of patent application, it's not an automatic. When you write a thesis, when you write a research projects, make sure that your research projects have some quality of novelty, inventive step. That is, it should be something, when you add the knowledge, when you gather the knowledge from the public domain, you create something beneficial or something added advantage or technically or something value added to that research. And then when you come out from your lab, something like with an inventive ingenuity, and that has a industrial applicability. When it qualifies all the three important criterias, you need to manually file. That is, you need to write your invention in a proper format, and then in a simple format, without any claims or something. Just you need to write it, and that is a you need to file that applications manually. It's not an automatic, you need to initiate it, the patenting process. You need to file it, that is a provisional application. If if you file a provisional application, then you need to file a complete specification within 12 months. That is, you can continue your research, and then finally when your research is in a shape, you get a 12 months time duration. And then once your research is in a final stage, within a 12 months you need to file a complete specification. In complete specification, your provisional specification does not have any claims. Now, the difference between the provisional specification and complete specification is, provisional specification, it only discusses the ideas, and it only discusses your invention. Okay. The complete specification, it also needs to have a claims. Now, claim is I will discuss more about claims. Claims is the core or the vital organ of the patent. It defines the boundary of your invention. Okay, so the complete specification has claims, so you need to file it within, after your provisional specification. Once you file a provisional specification, your priority date, the date on which you file a provisional specification, is the priority date. From that date, your 20 years of your patent lifespan starts. 1 year later you get a time. 1 year later you file a complete specification. You can instead of filing a provisional specification, you can directly file a complete specification also. But you require some time so that your invention comes to a shape. You can have a maximum of 12 months. And once you file a complete specification, then you need to file the that is examination, file for examination. So it's just a technical idea. In provisional application, you are filing a technical ideas. Should file your protection before disclosing it to the market, because it becomes a prior art for your own patent. So never kill your own patent by making it prior knowledge to the public or putting it in the public domain before you file a patent. Be careful about it. Next, the concept of priority. I told you, public notice. Then 18 months you get the time. Once you file a complete specifications, then 18 months, after 18 months duration, the patent office publish it in the official gazette. Okay, after you file a complete specification, whether it may be a direct filing of complete specification, or after you file a provisional, 1 year later you file a complete specifications, and then after 18 months you get a time, you get all this time of 18 months to analyze the market, where you want to launch your product, where all you will be getting your monetary benefits out of it. So this 18 months duration, it will not be disclosed to the public. It will be only with the patent office. this 18 months duration, you can utilize it to know your value or monetary benefits you can reap from this invention. So once it is published in the official gazette, it is into the public. Then after 18 months, you can file for examination, and once it has been examined, you get a first examination report. In the first examination report, the objections regarding to patentable novelty, patentability aspects, that is novelty, inventive step, and industrial applicability will be raised, or any of those objections will be raised, which you need to comply. So in order to once you comply all those objections in during that period of like once it is being published from the in the official gazette, then there will be the person who is interested, or any person can apply for a opposition, okay, for your invention, that this is already novel, or some criteria has not been fulfilled, or it doesn't fulfill the criteria of inventive step. Some who is really interested will oppose your patent. Once you satisfy all these objections, then on successful scrutinization of all your documents, your patent will be it will be decided by the patent office whether to grant it or abandon the or to reject the patent. Once if the patent office decides that it can be granted, then a sealing of patent, a patent certificate will be issued. After patent has been granted, then post grant patent, the duration of post grant patent or lifespan of 1 year starts. Within 1 year, if nobody, or in this case in post grant, after that is after grant has been patent has been granted, that is post grant, a person who is really interested or who is very much intellectual in that particular field only can apply for a opposition. Then the post grant oppositions takes place, and if it has been successfully proved all those aspects, then the patent can be sustained. So key points that need to be remembered is the invention. You need to mention your invention very clearly, thoroughly, without concealment of any information. Don't conceal any information. Keep it open. Even if there is any like concealment of information, then your patent can be revoked anytime after it has been granted. You lose your monopoly. So no concealment of information. It has to be very clear, precise, covers a concept. You need to cover your concept very clearly, broadly. Patent inventions, patentable inventions, it should fall under the patentable invention criteria. It should not be unpatentable invention. It should be it is a proper contract between the government, that is the releasing agency, that is the nation. Group of inventions, claims should be very appropriate, disclosure of invention, and the target audience of the patents. It should be very clear mentioning all these points. Now the final word or caution is the claims are vital organs of the patent. So those who are looking out for patents, be careful with the claims, because claims define the boundary, scope, and the boundary of the monopoly. So claim is the whole heart of the whole patent. So be careful with when you draft the claims. It must be supported by the specification. Whatever you say in the claims has to be supported by the specification. So specification can be very broad, but claims has to be restricted to the specific invention. Whatever is disclosed but not claimed is given to the public. That is, it is disclosed in the public. It is not claimed. The inventive step criteria has to be fulfilled. Before filing a patent, it is very important for the inventor or applicants to check whether their invention satisfy all these criteria of patentability in respect of novelty and inventiveness, because this all requires some investments. So thoroughly check it, and then conduct a prior art search and seek help of lawyers if there is any discrepancy of you, if you require any help out of it. Thank you. So any questions, please? Can raise questions on it. So I hope I cleared most of the queries. So
Yes,
now you
sir.
can shoot your
Uh,
questions
th-
forward.
yes, that was really a very great session, sir. Uh, you really have linked the dots between the academic intellectuals to the patients. That was really a very great session, sir. Thank you, sir.
Any
So,
questions?
yes, sir, we are moving on to the question session. So, I request the organizing committee, Mr. Deepak, to display the queries from our participants. So, there is a first question, sir. What is the geographical indication?
Geographical indication is very geographical restricted. Like a particular place is known for like if like Kanjipuram silk. So when you name a place, immediately you come up with the product, right? So that is the geographical indication. Tirupati laddu. Like when you say Tirupati, immediately what comes to your mind? The things that are linked to that particular geographical place. So that is a geographical indication that is well known, and it gives a monetary benefits. It gives the world out reach. So that's why geographical indication is more important, and you need to apply for geographical indications.
Yeah. Thank you, sir, for the beautiful explanation. Here we have the next question. Shall we publish a research work in journal before applying the patent? There you go, sir.
A good question, but if you are applying for a research work in journal before, but if you are like satisfying the conditions of novelty, patentability aspects, as well as if you find an extraordinary that is something extraordinary that has been coming out of your research, then before publishing it in journal, it's better to be publishing, like you can go for a patent. And once you apply for a patent, once you get a priority date, then you can go for a publication in research. There is no question about it. You can publish anytime in research journal, there is no question. But once you apply for a patent, that is once you, whether either it may be a provisional or a complete specification, once you apply it, you get a priority date, then you can go for a research publication in journal. There is no question about it. But you should satisfy the condition of patentability, as well as it should have a certain beneficial effect to the public. Then you can go for a patent better
Yeah.
than
Thank you, Muthu, sir. And there goes the next question. Good morning, sir. Can you explain the difference between para 4 fielding of patent? Will it be infringing patent laws? And yes, also thank you in advance.
Okay, thank you. Can you explain difference between para 4 filing of patents? Para 4 filing is with regards to generics, right? That is when the patent is in the boundary or verge of being getting outdated or being like, so once the patent duration is over, then you can then it won't be infringing any patents. But before, if you launch the deadline of the patent, then it will be infringing surely the patent law. You will get a marketing rights, right, by filing para 4 filings of patents. That's it. Para 4 filing. I think I have answered the query, but if you still, you
Yes.
can get in touch with me.
Yeah, okay. Thank you, Muthu, sir. So here comes the next question. Can a product be made from a group of natural products and can be patented, sir?
Yes, surely it can be patented. There is no question about it. It can be patented, but it should not be a mere combination. As I already told you, it should not be a mere combination of natural products. Like if you're taking 3 or 4 natural products and just merely combining it and coming up, okay, it can be used as a combinative, it can be used as a digestive juices. So that should not be. There should be some beneficial effect or synergistic effect. Like when it has been like administered individually, when it has been administered in combination, it should have a beneficial synergistic effect better than the individual effects. Then it can be patented.
Yeah. Thank you, Muthu, sir. Uh, Deepak, is there any other queries from our participants? It seems as if the questions are over, sir. So up next, I'd like to call upon our principal, Dr. S. Mohan, sir, to share a few words regarding the session. Over to you, sir.
Sir, mute.
Mohan, sir, your mic seems to be in the mute. Yeah, you're audible now, sir.
Yeah, thank you, Dr. Muthu, for your informative session and spending your valuable time for sharing your thoughts with our participants. And your topic is more important for our professional peoples because we are lack of this pattern process. We do always
Yeah, it's
lot of in the research part, but we don't know how to get pattern of our innovative work. So that's what is our long-term thoughts to have one eminent person from pattern discipline. I hope all my participants got benefit from your talk. So we have long-term relationship regarding this pattern process. Dr. Ramban will coordinate for this soon. And the plan is to have one separate session for this only regarding this,
yeah, sure.
upload this pattern process. Thank you very much
Today,
for your.
today whatever I discussed was a very basic about patents. So there are
Yeah,
many things that need to be. So we'll be surely assisting you whenever necessary. You can get in
yeah,
touch with
yeah.
us.
Thank you very much.
Thank you.
Thank you, Mohan sir, for your wonderful words. And up next, uh, from our organizing
So,
committee, we are very glad to present an e-memento to our speaker, Dr. S. Muthuvenkatesa. So I kindly request the organizing committee to share the e-memento to our speaker, Dr. Muthuvenkatesa, as a token of love and gratitude. And there you go, sir. So that is a memento being shared through the screen. And thank you, Muthu Venkatesh, sir, for your valuable time and your scientific session as well. Thank you, sir.
Thank you. Thank you very much.
Thank you, sir. And up next, I would like to invite Dr. S. Ramkant, the member of our organizing committee and head of department, Pharmaceutics, Karpagam College of Pharmacy, to deliver the vote of thanks. Over to you, Ramkant, sir.
Is it audible? Yeah, Gokul? Yeah. Gokul, is it audible?
Sir, sorry to interrupt. Your voice is breaking, sir. Your voice is not clear.
Is it okay now? Yeah, it's a great pleasure to share a vote of thanks for this wonderful session. And really, as principal stated, the work session will be very useful for the academic as well as the students community. And really, we're thankful for your for accepting our invitation. And this is the end session of the speakers in this international conference series. Thanks a lot, sir. Make the session really a wonderful session and make it useful for all the audience. Hope everyone will be stepping their research towards a patenting processes. And thank you all. Thanks a lot, sir. And to this session, I will be giving a small introduction about the validatory process. On behalf of organizing committee, thank you all the delegates for participating in all the events, inauguration and speaker session, e-PHARMINAR speaker session of 4 series. Thank you all. And most by waiting expected thing of validatory process that will be started by 2:30 p.m. The link for the validatory YouTube channel link has been shared in your email ID, registered email ID. So we expect all your presence and make the event a grand success. Thank you all. Thank you, Mr. for being with us and sharing with your valuable thoughts. Thanks a lot.
Thank you, Ramkant, sir, for your beautiful words. And with this, we've come to the conclusion of the session. There is a saying that the most successful event is the one that exceeds the expectations. And I do believe that we have exceeded our own expectations, which concludes this 2-day international webinar on a successful note. And as Ramkant sir said, the validatory function and prize distribution are to be conducted at 2:30 p.m. in the afternoon. So I request all the participants to join the validatory function through the links which will be shared to you through the mail. And thank you all, and we are going offline. Bye.
Thank you for the end the session. Thank you.